cases, and there are 4 teachers, 4 primary school teachers. I was removed on the issue of for KVS application Honorable Supreme Court's order. So regarding KVS, the Honorable Supreme Court clarified its order on 10/12. The order can be seen at page 39. And KVS was a party before the Honorable Supreme Court. If my lady should put and also just page 38 for a minute. It is the Honorable Supreme Court's order. And at 39, if my lady...
Yes, so this is effective from the date of the pronouncement of the judgment.
That is 28/11/20.
What is the date?
28/11/23 in the judgment.
Okay, yes.
And I have been removed relying upon the Supreme Court judgment, which is at page 29/11/23. I have been removed. It's C-52. On the basis of the Supreme Court judgment, which they wrongly understood. At 52, they say that we will not consider you. I am a part of the merit list. All 4 of us are part of the merit list.
Okay. So,
in addition to this, all high courts in the past 2 months have already implemented Honorable Supreme Court's order. I have put 2 examples. One is...
So, in the case of the present 4 applicants, this clarification has not been implemented. This is what you are saying?
I am saying the KVS has not implemented the clarification for anyone.
For anyone.
KVS has to do it because 4 of us are here. So therefore, KVS has to point out. Therefore, kindly take page 250. There is a legal notice issued by the judge.
Yes.
With the reference to the legal notice dated 20/22 on behalf of source. Since this is a policy matter, KVS has forwarded the judgment dated 10/12/24 of the Honorable Supreme Court, the Ministry of Education, requesting them to issue necessary direction for further course of action in issuing offer of appointment to candidates having 18 months DE, DLED diploma from NIOS. Further, Honorable Supreme Court by order dated 28/11/23 has declared 18 months DLD from NIOS invalid for post of primary teacher. A copy of the order is forwarded to the Ministry requesting them to provide direction. This was issued in January.
Yes.
We are awaiting a direction from the Ministry because it's a policy matter. So there is premature. It is premature for the time being. We are awaiting.
So how is it premature? How is he having...
It's a policy matter. We can't take a decision. He has to wait till we get direction. If we have to go on that aspect, 28/11 is the Supreme Court judgment. Within 24 hours, 28/11 is rejected.
When the very basis of rejection goes, then how can the rejection stand?
We are taking instructions from it. We are awaiting.
Subject to the instructions you
we will file a reply to this. I am sorry, I oppose that. Leadership, what I am trying to point out is, 1 second, sir. Why you shout? Please let me complete. I am the petitioner and the applicant. But don't raise voice, sir. Within 24 hours of the Supreme Court judgment.
I know that already.
Let me take it. Now they are saying file the reply. I'm sorry, I oppose that. No, admission coming for admission. There is already a petition filed by him. No, I'm sorry, it's not correct. For these applicants, there is no...
Wait. निकालते हैं रास्ता निकालते हैं भैया रुकिए.
In the first hearing, I will take instructions. Come back to you next week.
Where is that order? Which page? Just give me. Sorry, I couldn't flag it.
That page 38 it starts. 38 it starts, and the leadership will see 39. The first application is KVS. KVS is a party in that. KVS was served. So leadership would note at page 39, miscellaneous application line number 54987 of 24. Have that been implemented? They were parties. What is the need to be updated? Miscellaneous application has been heard. Please, yes, of course, they have been heard. Please see page 50.
It is on KVS's miscellaneous application.
The application that we have is on review. That stage, some miscellaneous application was made. I'm not sorry, it's not an implement. The application is reproduced. Please see page 56. 1 second, sir. Let me come. Don't say wrong side. Mr. Commissioner Rage on PC. Please see page 56 is the application. And KVS is mentioned as a party at page 59. Notice was issued 1 month prior.
Yes.
59, my ladyship and lordship would see. These are all 1 second, sir. Why don't you let me complete? What is the hurry? Page 59, respondent number 3 is KVS. They were issued notice in November of 24. Page 59.
Yes, I am good. Now, where is that order when you were removed on 29th of November?
I'm sorry.
page 52, Annex 8. That they take a decision within 24 hours, there is no policy, there is no ministry, etc. Now to implement, they are saying for the past 4 months we will set upon. It's so unfair as an applicant, my maybe should put some.
See, this 59 52 order,
Yes.
keeping in the judgment of this is a provisional list of selected candidates. A provisional list.
All the others mentioned in the provisional list have been given appointment within 10 days from that. If it's the provisional list, why did they give appointment to all others? I have put the very test also here.
I have to take some instructions on these things.
I'm sorry, where is the list?
We will give you a week's time.
No, that is
All will note it. Chali council miscellaneous application. पहले miscellaneous declaration 651 of 2025 for joining together for the reasons stated therein is allowed. फिर MA 650 for just exceptions. ठीक है. Counsel for the applicant submit that the present way has been filed at the section 19 of the AT Act on by the 4 applicants who were selected provisional list of the candidates for the post of primary teacher in KVS. Full stop. Owing to the decision of the Honorable Apex Court in Javeer Singh versus State of Uttarakhand, SLP number such and such, dated 28th of November 23, wherein the qualification of DELED from NIOS was held to be ineligible or not eligible for the post of primary teacher. The respondent KVS had had taken a decision to review the select list on the said decision by order dated 29th of November 23. Council submits that the not only the KVS but some other
all states examples are at page 2.
They had approached the Honorable Apex Court in review petition seeking review of the order dated 28th of November 23.
Yes.
While an order dated 10th of December 24, the said order of the has been reviewed and clarified that the clarification is effective from the date of pronouncement under review, that is with effect from 28th of November 23. As such, the very basis on which the notice dated 29th of November 23 was issued by the KVS does not exist as on date today. He submits that since the applicants were in the provisional list of the selected candidates, they are now fully eligible and in their right to seek appointment as a primary teacher, assistant and primary teachers. Third issue notice. So and so appears on behalf of the respondents.
There is one other respondent.
Accepts.
Schooling. That's not.
He appears and accepts notice. He draws our attention to the order dated 6th of January 25. To the letter dated 6th of January 25. He submits, which is a reply to the legal notice of the applicants to the KVS. He submits that they are aware of the legal position and in view of the order passed in review dated 10th of December 24, they have forwarded the judgment seeking further necessary instructions and directions from the Ministry of Education. He further argues that it is only an administrative approval for which the file has been sent to the Ministry of Education, and they are awaiting the response from the Ministry. In view of the statement made by the council, and he seeks a week's time, 10 days time.
They should provide 2 weeks time. Leadership could just see page 53. The Honorable Supreme Court has only implemented a sort of a BR. Since leadership could see 53 within 10 days. Please see 53 for a minute, and that was for state of Bihar. And the only question that troubles me is that why is the delay? So 15
कोई बात नहीं. And so also for the union also appears and seeks 2 weeks time to come up with the instructions. This is strongly opposed by the counsel for the applicant, who submits that the order of in review has already been implemented in the state by the Honorable Supreme Court itself in the state of Bihar, and there is no reason why there should be a delay or why the KVS should not be implementing the same. Looking into the above conspectus, and however, since the matter is only in the admission stage here, a week's time is granted to the respondents to come up with the latest instructions.
But you're not specifically direct,
the council of नहीं उसमें because you are sending the file ना.
No, we already said. Therefore, they have to act. They should be made to act.
The council of the KVS is directed to pursue their letter with the ministry, and council appearing for the ministry is also directed to act in accordingly. Chaliye.
Yes, so we are getting that. I in my interim prayer, I've asked for a stay on that 29 month because now it's covered by the Supreme Court order. So only that.
I've already said that the very basis is it doesn't exist. So उसमें रह क्या गया? 10 days. Order the state.
4 months. No, we are remembering for every 1 year. End of 28.
So unless the person is file moving. Actually, you see, so many.